आज के इस एक्सप्लेनर में आपका स्वागत है। Today, we're unpacking some absolutely crucial shifts in our legal landscape. We're going to decode the critical differences between magistrate statements and medical examinations under the new Bharatiya Nagrik Suraksha Sanhita, or the BNSS. Specifically, we're focusing on Kanuni Takhleek, the creation of new law around Section 183 and 184, which govern the highly sensitive procedures of recording confessions and conducting medical examinations.
Here is our roadmap for today. We'll quickly trace the journey from the old crime procedure to the new laws, dive into Section 183 for magistrate confessions, look at Section 184 for medicals, see how this all holds up as evidence in court, and finally look at some landmark judgments. All right, let's jump straight into Section 1, looking at the big changes from the CrPC to the BNSS. For all the legal professionals out there, you'll recognize this shift immediately. The old CrPC Sections 164 and 164A, they are now officially Sections 183 and 184 under the new BNSS. The numbers have changed, sure, or iske saath hi, the procedural safeguards have been seriously modernized. Now, you might be wondering, why do we need such rigid rules in the first place? Well, historically, we've seen instances where police coercion during investigations led to forced false confessions. Innocent long dabao mein aakar confess kar lete the, right? To fix this, the law created a firewall. It insists that investigating police simply cannot record these serious statements. Instead, a completely neutral judge or magistrate has to step in. Which brings us to Section 2, Section 183, dealing specifically with magistrate confessions. Section 183 doesn't just make suggestions, it lays down strict conditions. First off, the magistrate has to be completely neutral. They must explicitly tell the accused, hey, you are not bound to make a confession, and if you do, it can be used as evidence against you. The magistrate carries this huge burden to independently assess and ensure the confession is literally 100% voluntary. Bina kisi dabav ke.
And here is a real game changer in Section 183. These confessions can now be recorded via audio, video, electronic means. Plus, this can happen right in the presence of the accused's advocate. ये ऑडियो वीडियो टेक्नोलॉजी एक मैसिव स्टेप फॉरवर्ड है. It guarantees transparency, keeps the authorities accountable, and for sure drastically improves the reliability of the evidence in court.
To put this into perspective, take a look at these standard operating procedures from the Puducherry police. The procedural sanctity here is intense. The magistrate actually has to sign a memorandum certifying they truly believe the confession was voluntary. And here's a massive safeguard. If the person refuses to confess, the magistrate absolutely cannot authorize their return to police custody. Police custody mein wapas bhejne ka dar yahin khatam ho jata hai. Okay, let's shift gears to Section 3, Section 184, which handles the highly sensitive procedure of medical examinations in rape cases.
Section 184 introduces some incredibly strict timelines to prevent any delays. Step 1, the survivor must be sent for an examination within 24 hours of the information being received. Step 2 is getting explicit consent. Step 3 is an immediate examination by a government doctor. And Step 4, this is a crucial new addition under the BNSS, the medical report must be forwarded to the magistrate within exactly 7 days. Basically, file FIR karke police station mein dhool nahi kha sakti.
But the absolute bedrock of this entire procedure? It's consent. Subsection 7 of Section 184 is categorical. No examination is lawful without the consent of the woman or a person competent to consent for her. Literally no one, not the investigating officer, not the court, not the hospital, can compel a survivor to undergo this against her will. Unki dignity or autonomy sabse upar hai. Moving on to Section 4, let's step inside the courtroom and talk about evidentiary value. The burning question for any trial lawyer or judge listening is this. Kya Section 183 ke bayan, ठोस sabut, meaning substantive evidence, mane jate hain? Does this document alone have the power to actually prove a fact, or is it just supporting material? Well, as we can see here, there's a massive difference. A statement given to the police under Section 180 is not substantive evidence. You can generally only use it to contradict a witness. You definitely cannot convict someone based solely on it. But a statement recorded by a magistrate under Section 183, that is legally admissible as substantive evidence. Court mein iska wazan bahut zyada hota hai.
And this is exactly why retraction disputes are so heavily contested. Accused अक्सर trial के दौरान अपना confession वापस ले लेते हैं, claiming they were forced. But because of the intense procedural sanctity of Section 183, the neutral magistrate, the clear warnings, the video recording, if the court finds that the initial confession was truly voluntary, that statement can independently form the basis for a conviction, even if they retract it later.
Finally, let's ground all this legal theory in reality with Section 5, Landmark Court Judgements. Let's look at the 1981 Sawaki case. The court definitively ruled that statements given to an investigating officer lack two absolutely vital things: an oath and cross-examination. Because they lack these foundational safeguards, they simply cannot be treated as substantive evidence. Police confessions directly conviction tak nahi le ja sakte.
Now, contrast that with the Supreme Court's stance in the Dagdu judgment from 1977. The court upheld that confessions made to a magistrate do remain legally admissible even if the magistrate maybe missed a few minor procedural guidelines. The core admissibility stands, though the actual evidentiary weight might diminish a bit. The ultimate test always comes back to, was it truly voluntary? When it comes to medical examinations under Section 184, there was actually an old anomaly carried over from the CrPC. It didn't explicitly mandate a female doctor for a female rape victim. But the Karnataka High Court recently plugged this gap in the 2024 Ajay Kumar Bahara case. The court firmly mandated that until Parliament officially amends the text, these highly sensitive exams must be conducted by or under the supervision of a female medical practitioner.
So, what does this all mean for us? As the BNSS modernizes our investigations, bringing in mandatory video recordings, strict timelines, and neutral oversight, we are left with a vital question. How will our judiciary continuously balance these powerful new tools against the absolute need for constitutional fairness? The laws are written, but it's inside the courtrooms where their true impact will be measured. Aaj ke liye bas itna hi. Keep questioning and keep learning.